Here we got everybody. All right. Watson, I think you're up.
May it please the court, I'm Attorney Benjamin Watson. I represent the appellant Emily Trevino. I'd like to put aside 2 minutes for rebuttal, please.
I'm sorry, how much?
2 minutes.
Right.
You might have to lean into that mic.
Yeah, you're not
Your
coming
mic
through
needs to be turned up.
Either turn up the volume or lean forward, please.
We don't hear very well.
Yeah, well, I'm the oldest one here, Steve.
Okay, I'll speak as loud as possible when I'm talking.
You're
Can you
doing
hear me
that's
better
good.
now?
Yeah,
Okay.
that's great. Thank you, Mr. Watson. Have at it.
Okay, we're here on appeal today, appealing the final judgment on order denying our motion for new trial. Both sides agree in their briefs that the abuse of discretion is applicable to all the legal issues that we'll be discussing on appeal today. The one thing I want to emphasize within that is, yes, the trial court has this abuse of discretion, but the discretion, these are all evidentiary issues. So the trial court's discretion is limited to the rules of evidence. And I'm gonna come back onto that point. First, I'm gonna identify the errors that the trial court made. I'll give a summary of the facts, and then we'll tackle all these issues one by one. The first issue is the speculative conviction error. The second issue is the insufficient curative instruction error. And the third issue is the violation of the motion in limine order error. And it's our summary that based on the totality of all these errors, Ms. Trevino didn't have a fair trial, and the trial court abused its discretion. And we're asking for the final judgment to be reversed and proceedings to be remanded for a new trial so Trevino can have a fair opportunity.
Can I ask you a question? Because you had some great issues teed up, but the other side saying, hey, the judge sustained the relevancy objection, and then you brought it in, or your side brought it in on cross. Is that true or false?
Right. It sounds like to me you're discussing the what I label as the insufficient curative instruction error, and I'm going to talk about that second. And just to fast forward, the judge gave a curative instruction, but the curative instruction was clearly not only insufficient, but it was detrimental. And I will discuss that.
Well, I understand. It's always nice to segment the way you want it, but while we're thinking about it, did you ask for a better instruction, or did you object to the curative instruction at that time?
So what happened was, so it's at, we're looking at 874 in the record. And then this is when Ellis's trial counsel was discussing, oh, all right, so you were married to someone else at the time, and you had 3 children with someone else at the time. So after that question on 875 in the record, Ellis was arguing that his basis to support these questions was to establish that Guevara never showed Trevino how to drive the car. And I'm going to respond. Trevino moved for a mistrial, but the court merely gave a curative instruction, which was merely to disregard the last line of questioning. But our position here is, my opponent mentions in his brief, like, oh, we should assume that the curative instruction was sufficient, but not here. We don't have to do that because the trial court actually said that, you know, in 882 of the record, you know, if I give this curative instruction, it's actually going to be detrimental. I'm paraphrasing, but it's just going to remind it's just going to remind the jury of what the prejudicial testimony that just happened. So at this point, to really hone in on your question, Trevino's trial counsel moved for mistrial. The judge didn't give the mistrial. And so at this point, the judge had a decision, either grant the mistrial or give this curative instruction which the trial judge already conceded wasn't going to be curative at all, which would actually be detrimental. And so our position is the trial court abused its discretion. You have a decision to grant a mistrial, or you're going to give a detrimental curative instruction. You give the detrimental curative instruction, that's prejudicial and an abuse of discretion. And just one point on that, the Brooks versus State case, it's 868 Southern Section 643. It's a second DCA case. And it just pretty much stands for the principle, when any curative instruction would be insufficient, the trial court should grant a mistrial. And that's kind of how I'd answer your question on that.
But let me ask you this, how was the instruction insufficient? They told the jurors to disregard that I think the judge didn't say just even that question and answer. I think the judge said that line of questioning, didn't he? Something to that effect.
Right, and I appreciate that question. I understand, but when you look at the full record, the trial judge, I can dive deep into that and dive case law, but the trial judge, we don't have to do that here. It's my position because the trial judge actually tells the parties, if I do this, I'm just going to be reminding them of what happened.
Well, that's usually a clue.
Right. But again, the question is how was the instruction ineffective? You know,
Okay.
I mean, so I gather, if I recall correctly, there's an objection. There's a bench conference, correct?
Correct.
And then the next thing the jurors hear is the judge saying, disregard that line of questioning.
Correct.
How was that insufficient?
Again, and then it really goes into, and it's a deeper analysis than that. I mean, when you really examine the questions that are being posed, so you were involved with an accident, or at the time of the accident, you were married to someone else at the time, you had 3 children with someone else. And it's just the implications and the inferences that arise from these questions. And it's really, and again, this was Trevino's key witness. And it talks about how Ellis in his answer brief talks about how he was trying to lead the jury to make these inferences and these assumptions and all these leaps. But the case law that talks about this actually says that's actually improper. So essentially, the reason why Ellis argues in support of these types of questions is exactly the reason why our case law says you shouldn't be asking these types of questions, because the jury is supposed to be make their decisions based on the evidence that's actually in the record.
Right. But the judge sustained the objection, excluded that evidence, directed the jury to disregard it.
Right.
So where did the judge err?
Right, and that was my position. It's because the trial judge, and that's what I'm trying to focus on. The trial judge told the parties in 882, I can give you this instruction, but it's going to be detrimental. It's just going to remind the parties. And so the trial judge should have granted a mistrial. Is the abuse of discretion at this point. And then I refer back to the Brooks v. State, because the trial judge is noting, and pretty much the trial judge is speaking, the curative instructions is going to be insufficient. So right there, Brooks v. State, when any curative instruction is going to be insufficient, you should have granted a mistrial.
You don't get an automatic mistrial, even if the curative instruction is inadequate. That's a whole nother layer of analysis. Here, from having been a trial judge, I can tell you the judge is basically saying, hey, do you really want me to give this instruction? It's just going to remind them what they just heard that they shouldn't have heard. So maybe we should just move on. Rather than take that as a sign to move on, it was taken as a sign that the judge is now admitting that I should be granting a mistrial, but I'm not going to. But you can't bypass that intervening analysis. Say you just don't go from an objection to an inadequate instruction to a mistrial. There's a whole layer of things that happen before you get to that end game. And you're trying to do it on appeal now, but at the time to make all these objections and analysis was during the trial when the judge made that offer. Say, judge, are you saying X, Y, or Z, to put words in the judge's mouth that you're now trying to have us put in the judge's mouth? Because, you know, we weren't technically there, but from what I'm gathering, it sounds like it was more of a clue than a ruling on a mistrial. Anyway, sorry to interrupt you.
No, it's fine. But the other point, and I'll wrap this back up, but it wasn't just this issue when the trial court, when they were, Trevino's trial counsel was arguing for the mistrial. It was also this, the first issue, it was this issue, the insufficient curative instruction error, and then it was also the issue with regards to the speculative criminal conviction. And if I can proceed on that,
Sure. Sure. Of course.
Essentially, it's going to be all the totality of all these errors. So we discussed the second error I want to discuss. So we're going to go back to the speculative. I kind of want, it sounds like you guys know the facts pretty well, so I'll skip the summary of the facts.
Sure.
And so we have Mr. Rivera. He has deposition testimony and he has trial testimony, which I want to highlight. Mr. Rivera was, he was deposed. I'm looking at 346 in the record. Ellis's trial counsel, and this question is important. Have you ever been convicted of a crime of dishonesty, including theft? So it's crime of dishonesty, including theft is the question. Mr. Rivera says, yeah. So we'll stop that right there. That's Ellis's admission. That's you're going to hear it. I'm sure my opponent may mention it. And that's in their brief. This is his admission. He admitted to being convicted of a crime of dishonesty and theft. But if you look in this same, when the case law required that we look at all of this in the same breath, and I'm still on 346, 347 in the record, they continue. Mr. Guevara says, yeah, I had a petty theft in 2013. He doesn't say crime of dishonesty. He says petty theft, and I'm going to get to why this makes sense. And then the last question is that an approximation? And Mr. Guevara, the witness, says, I'm guessing. Stuff like this I don't really pay attention to. So this was at his deposition. He says, yeah, but I don't really pay attention to stuff like this. And so, like I said, this deposition was in April 2018. The trial was in May 2019. So we fast forward a bit. Mr. Guevara is about to get called at trial. There's been a year before trial. Ellis doesn't get a certified copy of the conviction. Nobody knows why. It's not in the record on appeal. What's the status of the conviction? So prior to Mr. Guevara being called, Trevino's trial counsel brings up the issue. Hey, we don't really know what's going on. We don't know whether he was convicted or not. Did he plead no contest? I'm paraphrasing from 852 in the record. If you look at 853, the trial court asked Ellis's trial counsel a direct question. It says, where is your certified copy? In direct response, Ellis's trial counsel says, well, it's not required. He didn't have a direct response for the trial court. It's not required. He admitted it in his deposition. So that goes back to that admission. But did he really admit to it? He just said, petty theft, but I don't really pay attention to stuff like that. And then, so at this point, and I'm going to get to why the trial court abuses discretion right here. At this point, the trial court, on 857 in the record, the trial court opines that, okay, it looks like he needs to have a certified copy, but he can impeach with the prior deposition testimony. Okay, and we agree, and that's fine. That rule of law, impeach with prior deposition testimony is fine. But where the court erred is you can impeach with prior deposition testimony subject to the other rules of evidence, and that's where the trial court.
But what happened here was not an impeachment. It was he asked the question. The guy said, "I don't remember," and he said, "Well." What he did was he took the deposition. He said, does this refresh your recollection? Read page whatever it was. And then the guy said, oh, yeah, crime of dishonest. I wasn't dishonest about it, but I do admit that there was a petty theft. I did that. Right? That's what happened. So it really wasn't an impeachment that what happened in front of the jury.
Okay, there's two things I'll say on that. Well, first, in regards to the particular line of questioning, so he says the exact question is from 870 in the record, but this time Ellis instead, as opposed to the question he asked him at the deposition, he doesn't say crime of dishonesty and petty theft. And this may seem innocuous, but we're talking about a witness, we're talking about a lawyer. So, and he said, you were convicted of a crime involving dishonesty in approximately 2013. This is his question at trial. And then Mr. Guevara says, I don't recall that. And when I interpret this, he says, I don't recall that. I took that as a no, not I don't remember. And my analysis and my interpretation is supported by the record because
you can say that's how you interpret it, but the words he said was, I don't recall that. So, I mean, that kind of suggests, I don't remember. I mean, at that point, there was a discussion again at the bench. There was an objection. And he says, well, you can, like I say, you can refresh his recollection.
Right. And my analysis is actually supported by the record. If you look at 871, after this, I don't recall that statement was made, Trevino's trial counsel says, hey, there you go. Ellis said a crime of dishonesty. So they're trying to point out that he's saying crime of dishonesty and petty theft. But he said Ellis said crime of dishonesty, and Mr. Guevara said no. And so that was the statement that the Trevino's trial counsel made, and that's at 871, 9 through 15. So I would argue that my interpretation is more accurate with the testimony and the arguments made on the record. That I don't recall that is actually a no. But I'll continue to why that argument is still a bad argument. So the court allows him to refresh his recollection under the presumption that this I don't recall, which we're saying is a no, maybe he doesn't remember. But if you think about that even more, he was just deposed and asked a similar question. So it's not like he doesn't remember if he was convicted, or it's not that he doesn't remember about this criminal issue. It's he doesn't understand that Ellis is trying to Mr. Guevara is differentiating between crime of dishonesty and theft. He was asked,
right, and he made that clear in front of the jury after he read that his recollection was refreshed. Question: does that refresh your memory about whether or not you had a conviction for a crime involving dishonesty? Answer: the dishonesty, no, because I was honest about it. But the petty theft, that I did.
Right. Two things on that. So, and his response actually also confirmed.
And then that was it. That's the last time that comes up, correct? That this trial moves on.
Well, the trial moves on, but then what happens is he gets questioned about those collateral matters, what we discussed first. So there's
Yeah,
just.
But that part is over with at that point.
No, that part actually happened. This part actually happened first. This was the first, on cross-examination.
What I'm saying is the part that you're complaining about, the petty theft conviction, that what you and I together have just described. That's it. Pages 870 through 873 of the transcript, basically, at trial.
I don't think I understand your question exactly.
I think you're moving on to the other collateral matters, but the stuff about whether he was properly impeached or had his memory refreshed, that what we've just described, that was the end of the discussion, correct?
That's the end of the testimony. But again, I mean, this happened, and this line of questioning happened before the questioning with regards to was he dating someone else.
I get it.
Okay. But again, so Mr. Guevara's response was the dishonesty, no. So again, if you look forward, before, if we just rewind a little bit, he said you were convicted of a crime of dishonesty. I don't recall that. And so again, he said the dishonesty, no. So again, I don't recall that was essentially a no. And he's confirming that, like you said, Your Honor. And then to fast forward a little bit on this, and the issue really with this is where I want to highlight the State versus Jews Donnie case. It's 98 Southern 3rd, 1264. And this is why it's really perplexing is, okay, you're going to refresh his recollection, but he doesn't know. How do we know he knows? And State versus Jews Donnie case says witness may have a good heart belief, but he may not know. So the question is really, was this sufficient proof under the Florida Rules of Evidence that he was convicted of? We don't know. He doesn't even understand the difference between a crime of dishonesty and petty theft. How are we going to rely on a statement that he was convicted of a crime? So in State versus Giussani talks about that. Another thing I'll talk about in that case is actually more compelling. The witness in that case said, I went to jail. And then on appeal, the first UCA said, hey, yeah, even though he went to jail, it's still speculative as to whether or not he was convicted. So I would argue saying, yeah, I did, or I don't really pay attention to stuff like that. The dishonesty, no, it's way less convincing than a statement that he actually went to jail. So I would argue that that's a point. Another side note is like Ellis is making these arguments. It's like, okay, you comply with one rule of evidence, you still got to comply with others. So if we can impeach him, but the brick wall their analysis is always going to hit is that they didn't have sufficient proof under Rule 9613.
But he wasn't impeached. That's the point. There wasn't an impeachment.
Right. If it wasn't an impeachment, it's still improper refreshing recollection because of the inconsistent questions that were being posed. Essentially, under what rule, any rule of evidence you would now do this analysis, it's still going to fail. If it's impeachment, it wasn't inconsistent questions. He was asked one question at trial, and then he was asked a different question. Or he was asked one question at deposition and asked a different question at trial. And then the refreshing recollection, again, how are you going to refresh his recollection? What if he doesn't know? You might refresh his recollection based on a mistaken belief. And then the question I posed to the...
Well, he had an opportunity, having read what he said at the deposition to explain it, his answer then too. I mean, he had that opportunity. He was given it.
Right.
Does this refresh your memory?
Right. I think...
You are down to 2 minutes, Mr. Watson. We have helped you use your time. So you need, if you want to preserve your 2-minute rebuttal, you need to stop.
Yes.
Okay. Mr. Steinberg.
Thank you. May it please the court. My name is Brent Steinberg and I represent the plaintiff, Anthony Ellis. Your Honors, the issue before this court is simply whether the trial court abused its discretion in denying the motions for new trial and mistrial. And the defense raised 3 issues in their brief and again today. On the first issue about the Mr. Guevara's marital status and children, just so we're clear, it was defense counsel who elicited the testimony they're now claiming as prejudicial. That's invited error. On the second issue, defense argues improper impeachment, but as Your Honor noted, Judge Northcutt, we didn't impeach him at all. Counsel just refreshed Mr. Corvera's recollection with his deposition transcript as is permitted. And then on the third issue,
You did impeach him with character, alleged, arguably permissible character evidence about having been convicted of a crime of dishonesty, but that specific episode was a refreshment of his recollection, correct?
Correct, Your Honor. And thank you for clarifying. Just asking the question of whether or not someone was convicted is impeachment to credibility.
Right.
But it's not. We didn't impeach him with his prior deposition transcript, which is what I meant to say.
Right.
And then on the third issue about Ms. Torres's testimony, defendant didn't make a contemporaneous objection. So this case should be pretty straightforward. There's no basis in the record to find any error at all, much less an abuse of discretion. Now, if I could just touch on this marital status and children question and make sure we're on the same page here about the instruction that was given and all that, and explain to court how it was invited error. So on cross, plaintiff asked Mr. Guevara whether he was married and had 3 children with someone other than the defendant, whom he had just started dating at the time of the accident. And the defense objected. And before Mr. Guevara answers the question about whether he had 3 children with another woman, there was this sidebar. And at that sidebar, the trial court sustained the defendant's relevance objection and instructed the jury to disregard the line of questioning. Now, for the first time I'm hearing today that the instruction that was given was insufficient. And I think it's important that we have some context here. If we look to the record, and I'm at page 880, and the initial instruction that was requested by defense counsel, Mr. Amos, was to ignore the question regarding him cheating on his wife the night of the accident. And then Mr. Cathy, plaintiff's counsel, says the question was, you have 3 children. It wasn't anything about cheating. And then it goes on. And then this is after the court had sustained the objection. And then later on, during this back and forth, Mr. Amos again asks to ignore questioning with regard to the relationship status of the individual on the night of the accident as it relates to anything other than Ms. Trevino. And then the court said, okay, now you do understand you're just reminding them of the conversation. And then Mr. Amos says, all right, he knows more. And then indicating to his counsel. And then the court settles on jury disregard the last line of questioning. You don't even want that. And then he says, no, I'm fine with that. So there was agreement among defense counsel, and there were 2 of them who were talking, to just go with the disregard the last line of questioning, which is precisely what the court gave. And then on redirect, it was defense counsel who asked Mr. Guevara whether the fact he had 3 children with another woman affected his ability to see the plaintiff's oncoming motorcycle. So after keeping the testimony out about Mr. Guevara's relationship and getting the instruction, defense counsel brings it up on redirect. And now they're saying that these facts were so prejudicial that it deprived them of a fair trial. And of course, the problem with that in the defense's position is that the only evidence about Mr. Guevara's relationship with that other woman was put in by the defense. That is a textbook example of invited error. And of course, the defense isn't entitled to any relief that they caused. If there aren't any additional questions about that, I'll move on to the second issue about the conviction. So again, the defendant says that a new trial should have been granted because the plaintiff's impeachment of Mr. Guevara was improper. But the plaintiff's counsel didn't impeach Mr. Guevara at all. Plaintiff's counsel only refreshes recollection. As we discussed, it was his prerogative to volunteer the actual nature of the conviction. And counsel
the appellant side contends that, and contended at trial, that that was not a proper way to impeach on that topic, that you needed to have certified copies of the judgment.
Well, we didn't impeach with the deposition at all, but even if we had, it's appropriate to impeach.
Well, as I said, bringing this up was an impeachment. The topic, the fact that he had had this conviction was, a character, evidence on his character that was an impeachment. But the other side contends in order to do that, you had to have certified copies of the judgment. What do you say to that?
Well, Your Honor, 9608 subsection 1 allows impeachment with a prior inconsistent statement. And in Derrick v. State in 1991, the Florida Supreme Court held that a witness may be impeached about prior convictions by referencing the witness's deposition testimony. And that was even if the counsel didn't have a certified copy of the conviction in hand. That case is directly on point and it's binding on this court. But, again, we don't even need to get to this issue because plaintiff's counsel didn't impeach him with the prior deposition transcript. He admitted to the conviction. And there is some dicta in some of these other cases, the State v. Josdani case, for one, that was referenced, that talks about generally when someone denies a conviction, then you're supposed to impeach them with a certified copy of that conviction. But Josdani is a DCA case that is it's just restating the general rule, and it's dicta anyway. The rule is that with or without a copy of a certified conviction in hand, you are permitted to impeach with a prior inconsistent statement, which counsel could have done had he not admitted to it on the stand. But again, the trial court correctly allowed the plaintiff to refresh Mr. Guevara's memory. You could refresh his recollection with anything. He could have held up a stuffed elephant, and if that somehow triggered his memory about whether or not he would have been convicted of a crime of dishonesty, that would have been permissible under the rules. So I'm not really sure what counsel was getting at as far as the method of refreshing his recollection being improper. He had an opportunity to explain himself, and he gave the answer that he gave, and that was his prerogative. Unless there are other questions, I'll just come back to the standard of review here. It's abuse of discretion for every issue on this appeal. Mere disagreement with the trial court isn't enough to reverse. The defendant bears the burden of demonstrating that no reasonable person would have viewed the matter as the trial court did. Of course, the court had the discretion to deny a motion for mistrial with respect to all of the issues, particularly on the first one about Mr. Guevara's marital status and children. Let's keep in context. These were two rather innocuous questions during a 4-day jury trial. The court had the discretion to consider the question as it came in, and the cases the defense is relying upon to argue abuse of discretion are completely distinguishable cases where highly inflammatory and completely irrelevant evidence was admitted over the defendant's timely objection, which is unlike this case where the court sustained the objection and gave the curative. No harmless error analysis was required because the court didn't make any error. It sustained the objection, and defense counsel is not arguing that a harmless error analysis should be applied, and correctly so. We agree under Goodwin v. State, Florida Supreme Court case from 1999, that when you sustain an objection and you give a curative instruction, there's no need for the plaintiff to demonstrate harmless error. So just coming back to the very high abuse of discretion standard here, and any abuse has to be clear from the record. The defense simply hasn't met its burden. So if there are any additional questions? All right, well then we would just respectfully request that the court affirm the final judgment. Thank you for your time.
Thank you, Mr. Steinberg. Mr. Watson to rebut.
I believe I only have a limited time, so I'm just going to bring up the last issue, was the violation of the motion to limit order error. Ms. Torres was questioned at her deposition just 2 months before the trial in March 2019. Her deposition testimony was basically she broke up with Ellis because he was involved with other women. But then at trial, just 2 months later, you wouldn't expect her testimony to change, but it changed. There was a motion to limit between the deposition and trial. Ellis's 5th and 6th motion to limit, where they sought to exclude any evidence relating to why the dating relationship failed. Ms. Torres was called. She was, and then in an effort to abide to that order and preparing for trial, and I talked about the trial preparations being affected because Trevino's trial counsel wanted to comply with that order in limine. Ellis's trial counsel, they bring up this issue, and really why it's substantially prejudiced is because it led to the improper jury influence. And we talk about that, and they talk about that at the trial court level, and you can see that the improper jury influence with regards to the pain and suffering damages that were awarded here. And it's also just kind of based on these questions that are asked relating to it's the unrectified testimony, this unrectified restricted testimonies. So for example, if you hear I'm having a conversation with somebody and I say I got in a car accident, and after the car accident, my girlfriend dumped me because I was in a my injuries related to the accident, you'll say, oh, wow, okay, you might feel bad. But let's say I got in a car accident, my girlfriend dumped me, but it wasn't related to the accident because I was involved with other women. So the jury is going to make that assumption, and then you can see that with the damages. And again, it's the totality of all these errors, the speculative conviction error. At the end of the day, is this court going to, does this court going to say that that admission and that deposition testimony that I cited to, was that sufficient under the rules of evidence to show that somebody has been convicted? I don't think it is. And then, so it's the totality of that error, the insufficient curative instruction error, and then the violation of motion to limit error. Based on the totality of all those errors, the trial court abused its discretion. Tribunal did not get a fair trial. Guevara was Tribunal's key witness. And so we're asking for a reverse and remanded for a new trial. And Tribunal just wants to present her fair defense in court. Thank you.
Okay, great. Thank you, Mr. Watson. Thank you both very much.
Thank
The
you.
court will be